Doctrine of eclipse and doctrine of severability. These are the two constitutional principles that we observe while we study Article 13(1) and Article 13, Class 2 of the Indian Constitution. Article 13(1) deals with the pre-constitutional laws, whereas Article 13(2) will talk about post-constitutional laws. Here, this Article 13 will deal with two kinds of doctrines: doctrine of eclipse and the doctrine of severability. Very interesting and most crucial interpretations of the Constitution, constitutional principles, we can say. What is this doctrine of eclipse? We shall study now. If any law, that is pre-constitutional law, is inconsistent with the present law, that is, law here means ordinance, enacted laws, rules and regulations, the customs, everything, it will be included. If any law is quite consistent with the fundamental rights of the constitutional provision, then that part will be kept in suspense, kept in a dormant stage. See, the entire law will not be removed. Only that particular law will be valid as it is. Only that part which is inconsistent with the fundamental rights, the constitutional provision, only that part will be kept in suspense. It will be inoperative. When and until when? That is the question. It will be inoperative till the amendment takes place. The amendment of with the advent of the amendment of the Constitution, and that amendment is suppose that amendment is in tune with the fundamental right, that is the point to be noted, then it becomes valid. Again, it becomes operative. Life is given to that part of that eclipsed part of the law. For example, let's take one case law. Because Narayan versus state of Madhya Pradesh, here the state government, with a selfish vested interests, has enacted one law, Berar Motor Vehicles Act 1947. According to that, the complete monopoly of the business, transport business, was taken over by the state government itself without giving any scope to the individuals, the citizens. In fact, according to Article 19, 1 plus G, every individual citizen has the right, fundamental right, to follow their own business, profession, wherever they like. But it is quite contrary to that, inconsistent to the fundamental right of the Indian Constitution, that is the 19. Then, when it has come to the notice of the court, with the advent of the first Amendment Act, Constitutional Amendment Act 1951, it has been replaced. Some restrictions were imposed on the state government, and some relaxations to the in tune with the constitutional fundamental rights. And the 19 subclasses 6 article was given so that the individuals can follow their own business, their own profession anywhere in the country. Then the law has become operative with the restrictions imposed on the part of the government, and 91 with the induction of that Article 19, subclass 6, in favor of the citizens to follow their own business, profession, etc. This is a doctrine of eclipse, means the part of the law will be inoperative till the amendment, adjustment has taken place. Okay. And next, the doctrine of severability. This doctrine of severability is very interesting, and it is very easy also to understand, because a severable means separated. See, the inoperative, that inconsistent part, inconsistent means inconsistent to the constitutional provision, that is a fundamental right of the Indian Constitution. If it is inconsistent, that part, that part will be completely severed, removed from that law, and the other part of the law will be remaining as it is, without any change. That will not be amended. Only that part which is inconsistent will be severed, removed. Here, an important case law, that is A.K. Gopalan's case. A.K. Gopalan case, in the A.K. Gopalan was arrested because of the section 14 of the Preventive Detention Act. He was he made some obligate derogatory speech, and as a precaution, he was arrested, kept in the jail. He made an appeal, though he could not be successful in that case. Later on, that Section 14 of the PD Act was found to be quite contrary to the fundamental rights. That is, Article 19, 14, 19, and 21. Triangle, golden triangle of the fundamental rights. So that part, Section 14 of the Preventive Detention Act, was completely removed. The other part was it will be as it is. And same is the case with Maneka Gandhi also. Passport Act, Section 10, Class 1A. According to that section, her passport was confiscated without giving any opportunity for her, for the hearing also. It was quite arbitrary, quite opposite, contrary to the inconsistent to the fundamental rights. That is 14, 19, again 21. Then it was removed afterwards. We know very well about it. So that is doctrine of severability, and this doctrine of severability and this eclipse, when they will be dealt with in the process of judicial review, then only it will be when we at the time of judicial review, these two will be separated and clearly analyzed, and justice will be done. Because here the thing to be noted is, in the judicial review, while they are dealing with the doctrine of eclipse and also doctrine of severability, what is established is two things are established. That's first one is supremacy of the Indian Constitution and supremacy of the fundamental rights. That is the greatness of our judiciary and also our Indian Constitution. Thank you very much for your understanding about these doctrines. Thank you.